Thank you for watching the Housing Oregon YouTube channel. Be sure to join our network and get involved in the work that we are doing. If you can, please like and subscribe. It helps us build this channel, which serves as a platform to communicate with our members. This video is part of our 2025 annual conference. We're looking for folks to be on the conference planning committee. Please email info@housingoregon.org.
Morning. Okay, how many people are like, I'm a morning person? Raise your hand. How many people are like, I am definitely not a morning person? And how many people are like, I have not had enough coffee to be asked these questions? Thank you for your honesty. I appreciate that. So my name is Shyle. I'm the Education and Outreach Director at the Fair Housing Council of Oregon. I use she, her, hers pronouns. So I'm going to be completely transparent. My session was supposed to be today at 3:30. That's what the email said. And when I opened up the conference program, I learned something different. So I'm here at 10:30. My co-presenter, Nicole Last from Resolutions Northwest, was not here at 10:30. So instead, for the second portion of this presentation, we will have for Housing Council of Oregon's legal director come in, Stephen Crawford, and he's going to talk about legally how situations of hate and harassment get resolved from an enforcement standpoint. So still very, very valuable sort of pivot. I feel very fortunate that he's here and he was able to step in for that. So let's go ahead and get started with this. So how many people have heard of the Fair Housing Council of Oregon? Okay, how many people have not heard of us? Okay, one person's being honest about that. For all the other folks that did not raise their hands, I am always really happy when folks have not heard of us and are coming to a session, because you'll have a really good idea after this session what type of work that we do and also how we can help support you in the work that you do. So I do want to mention also we offer educational trainings, and we're a statewide organization. So if you sit through this presentation and you're like, man, I would love it if my team had a fair housing training, hit me up. Absolutely hit me up, because we'll be happy to try to figure out how we can make that happen. Also, if it's a little bit later and you're like, man, yeah, we should really have a fair housing training, but you can't find me, we're not here, we actually, over by the registration booth, have our own info booth. So please stop in there, because anybody at that info booth can also help you get connected around that. So our organization, we are actually a statewide civil rights organization. So we have team members in Southern Oregon, Eastern Oregon, Central Oregon. We've got somebody who also covers the coastal region. And I myself, I cover the greater Willamette Valley and the Portland metro area. So Lynn, Benton, Lane, Marion, Polk, Yamhill County, Multnomah, Clackamas, and Washington counties as well. So our mission, what the work that we do, is to end housing discrimination and ensure equal access to housing choice. And how we do that through education. So when I say education, we're literally educating everybody across the board. So anybody that's touching the housing process. So we're educating consumers of housing. We're educating advocates, case managers. We're educating housing providers, and that could be shelter providers, nonprofit housing providers, CDCs. It could be for-profit housing providers. It might be housing authorities. And we are also educating jurisdictional bodies, because literally anybody that is touching the housing process has responsibilities under the Fair Housing Act to ensure equal access to housing choice for protected classes. So we also have an enforcement team. Our enforcement team, Stephen, you can check me on this. So this is Stephen Crawford, our legal director. So our enforcement team, they house two very important programs. One program is our hotline. So if people believe that they have experienced housing discrimination, they can contact our hotline. Also, we have a tester program, which is sort of like a secret shopper program. So we can send out testers. If somebody believes that they've experienced housing discrimination, we may be able to use our testers, and that's to either call landlords to figure out if discrimination's happening, or we send out testers. So the way that that happens is, if we get somebody that calls our hotline and they're like, hey, this is what I experienced when I was trying to apply, then we have two testers that we use. One person that has this secret identity, and maybe it's that they have a Section 8 voucher, right? because the landlord told that caller for us, I don't rent to people with Section 8. So we give somebody a secret identity with a Section 8 voucher, and then somebody a secret identity that's exactly the same minus that Section 8 voucher. And we're testing to see what that landlord says to each of those people, right? That's how we suss it out. So if you've ever had a desire to be a secret agent and also to help, right, with how the housing access for folks, we are always looking for more testers, specifically also testers that are representative of protected classes that are more likely to be discriminated against in housing. So think about that. So today, we're going to talk about the basics of fair housing and fair housing implications for acts of hate and harassment that happen in housing. We're also going to review guidance related to landlord responsibilities with hate and harassment. And then we are pivoting, so this is no longer the last bullet point. The last bullet point is we're going to talk about how things get resolved from a legal standpoint when there may be hate or harassment. Also, Stephen is allowed to embellish how he would like as well. Since he is stepping in as our pinch hitter, we really appreciate that. So what is fair housing? Fair housing is the right of all people to be free from illegal discrimination in any type of housing transaction, in the rental, sale, or financing of housing. These laws really affect the entire rental process. So when somebody is applying to housing, fair housing applies. When somebody is living in housing, fair housing applies. When somebody's in process of moving out of housing, fair housing applies. So what does discrimination mean? I want us to have a really good shared definition of discrimination when we talk about it in this session, because discrimination actually has legal implications under the Fair Housing Act, and it means treating a person differently because of their protected class status, right? So treating them differently because of their protected identity. So this may be that landlord saying, I won't rent to you because of your Section 8 voucher. Right? Section 8 voucher is a protected identity. But let's say I'm a landlord and I say something like, somebody comes to apply to housing and I see they have an orange Volvo and I don't like orange Volvos. I could say, I'm not renting to you because you own an orange Volvo. Well, that's not actually any kind of a protected identity, so that's not considered discrimination. So when we talk about discrimination, it means that there's some type of an illegal act that has happened, but it was based on one of these protected identities. Does that make sense to everybody? Okay. So let's talk about the protected classes. We have several different levels. We've got federally protected classes. The state of Oregon adds additional protected classes, and then some local jurisdictions will add even more protected classes. So on the federal level, we have race, color, religion, and national origin. These were the first 4 protected classes that were added in 1968 when the Fair Housing Act passed. And then in 1974, with the women's movement, that had been going on for many decades at that point, we see sex being added as a protected class. Now, sex also includes survivors of domestic violence because the majority of survivors of domestic violence identify as women or femme. So if a landlord has a policy then that would screen somebody out or treat somebody differently, but that's related to their survivorship of domestic violence, they get special protections. What I will also say is there are Oregon landlord tenant laws that add additional protections. So if you are not familiar with those, I would highly suggest reading through them. They're a very interesting read. Okay. In 1988, we see familial status being added as a protected class, so families with kids. Here's a nice little fact for you. Prior to 1988, in the state of Oregon, nearly 70% of landlords would not rent to families with children. Nearly 70%. So imagine how hard it is to find safe, stable, affordable rental housing if 70% of that rental market is off limit to you. And the reality is we can pull up statistics like that for any one of these groups, which is why we have these protections in the first place. Also, in 1988, we see disability being added as a protected class. This is around the time that the independent living movement had been happening for a couple decades, and so people are trying to move out of institutions, trying to move into the community, finding they didn't have equal access to housing choice. So we see that getting added as a protected class as well. Now, Oregon adds additional protections. So marital status, if somebody's married, single, widowed, or divorced, it should not matter in a housing transaction. Also, source of income is protected. This does not mean source of income from like a job. This is really source of income like benefits that somebody gets to help pay the rent, for example. So that could be like a housing choice voucher, like a Section 8 voucher or a shelter plus care voucher. It could be a housing subsidy from a nonprofit organization. Now, benefits, other types of benefits like TANF, SSI, SSDI, they're not expressly listed in the law, but legislative intent was to include other types of benefits as well. So why I bring that up is if a landlord says, I'm not going to count your TANF income as part of your total household income, we have heard of cases settling on behalf of the complainant under source of income. So we tell housing providers, just assume any type of public benefits that are helping people to meet their basic needs, assume that is part of income, right? Also, sexual orientation and gender identity is protected here in the state of Oregon. So no matter what happens on the federal level around these protections, we have them in the state of Oregon, which is wonderful news.
I would just like to add, since we were talking about sexual orientation and gender identity protections, despite what you may have heard from the current presidential administration, those are also still federally protected classes. They are protected as a result of case law, and you cannot get rid of case law with executive orders. So those are still, at least for the time being, until something else makes its way to this problematic Supreme Court, those are still good law. So I just like to make that clarification because the federal government would like you to think that you don't have recourse through federal avenues right now. You still do as of this moment.
Thank you, Stephen. See, this is why it's so helpful to have your legal director with you when you're doing presentations, because he's like, and think about this. It's like, yeah, absolutely. So also, there might be additional protected classes in your locality where you live. So for example, Multnomah County adds age over 18 and also occupation. Salem, for example, adds an additional protected class of housing status. So let's say that somebody might have a barrier to get into housing, but that barrier was related to the fact that they were living outdoors for years. They can ask the landlord to take that into consideration when they get screened, which is really great. Eugene adds age over 18, occupation, ethnicity, and domestic partnership. So you'll see that in different areas. So always good. You can go to our resource library online. We have a fantastic resource library. I'm not just geeking out about that because I like fair housing. It's a really good resource library. So we have a lot of educational materials. We also have recorded trainings online as well for resources. So, okay, we're going to get into the meat or tofu and potatoes of this, okay? So, harassment in rental housing and also HOA governed communities. So I'm really going to talk about what harassment is, what it looks like, some cases that have come out as a result of that. So there are laws that protect people's rights in housing. So people under Oregon landlord tenant law have the right to peaceful enjoyment of their rental unit, of their housing. There's federal fair housing law as well, so Section 818. So September of 2016, guidance was put out specifically around acts of hate and harassment. And what that guidance says is, if there is harassment that happens in somebody's housing, and it is based on one of those protected identities, it does in fact become a fair housing issue. And the landlord or the HOA is responsible for investigating that act of harassment and then actually taking action if that harassment in fact did happen and it was based on protected class. What we know, so here's what we know. There is an increase in complaints to us about acts of hate and harassment. Also, the Southern Poverty Law Center tracks this, and what they can say definitively is that since November of 2016, there has been an increasing rate of acts of hate and harassment happening. I will let you draw the line that you can draw to November in 2016 and what happened at that point, right? We sort of thought that it might slow down at some point, and it just hasn't. It's been increasing. A lot of these acts of hate and harassment are really, really focused on immigrants, Muslims, African Americans, Jewish people, women, folks that are part of the LGBTQIA plus community. One thing that we also know is that when any of these groups start to get mentioned in the media, oftentimes what we see is spikes of acts and hate harassment then against those communities. So, you know, when there's talks about bathroom equality, right? For folks who are trans, when that comes into the news, we always know that there's going to be a spike in acts of hate and harassment against those communities. We wish that wasn't so, but that's the truth. What we also know about acts of hate and harassment is that 1/3 of all acts of hate and harassment actually happen in housing. Right? That's a really significant number. And Southern Poverty Law Center says that only 1 in 15 acts of hate and harassment ever gets reported. And I think it's really important that when we think about that, it's important to look at the groups who are most likely targeted by these acts of hate and harassment. And oftentimes they may not have the best relationships with those law enforcement entities that they should be able to report to, right? That's the truth of the matter. So let's talk about different forms of harassment that might happen. It could be words, especially if it's a threat and it's continuing over time, right? So it could be in the form of words. It could be actions. So for example, spying, touching, leaving derogatory messages on somebody's car, on their door, slipping a note underneath their door. It could be emails, texts, or social media. So when I do this presentation to housing providers specifically, sometimes they'll say, well, if that harassment is happening on social media, am I expected to be friends with all of my tenants on Facebook or Instagram? No, absolutely not. If that harassment is happening on social media, it is the person that's experiencing the harassment. It's their responsibility to take a screenshot or somehow document that harassment. Because people need to document the events as they are happening. Because then if there's an organization like ours that may step in, that documentation becomes really important and really helpful. So one of the things that I will say about our hotline staff is that we receive over 2,000 contacts a year about possible acts of discrimination. Over 2,000. We have 3 people that work on our hotline, right? So what that means is we cannot help everyone that contacts us. That is just the reality of it. So one thing that is very, very helpful to our hotline staff is that if somebody is experiencing housing discrimination or believes that they've experienced housing discrimination, to make sure they are documenting in some way, shape, or form what is happening. So that could be taking screenshots of those, that hate or that harassment that's happening on social media. That could be creating a written log, right? Date, time, what happened, who was involved, what was said. Are there witnesses to those things, right? Is it notes being left? Keep those notes, right? So creating documentation around the events that were happening. That is really helpful if we might need to step in, or Oregon Law Center, or Legal Aid, or one of these organizations. BOLI also can be very helpful. It may be displaying hate signs like swastikas. What we see is that in most cases with acts of hate and harassment, it's more than one incident. However, even a severe incident, just a one-time incident, could qualify as an act of hate or harassment. And again, what we know is that there is a national uptick in acts of hate and harassment, specifically against protected classes. Now, I want to be really clear. Ooh, you should answer that. I want to talk to them. Hey. Can I talk to you about fair housing right now? We've been trying to reach you about your car insurance. Okay, so not all harassment that happens in housing is actually a fair housing issue. So, for example, some of my predecessors were doing a training in Southern Oregon, a property that was owned by a housing authority, so public housing property. And the property management staff said, we have these 2 older women that live in our complex, and they hate each other. They're harassing each other all the time. But it turned out that harassment, it wasn't based on any protected class. So because it wasn't related to a protected class, it wasn't a fair housing issue. Now, if one woman was harassing the other woman, making derogatory statements about, you're a woman, or you're disabled, or, these things, then it could become a fair housing issue, right? But in this case, they were just hating each other. The landlord decided to do nothing, and this actually culminated in an argument in the laundry room where one took a full bottle of liquid detergent and threw it at the other one. Whew. Spicy older women, right? Spicy older women. But because that harassment wasn't based on any kind of a protected class, it wasn't a fair housing issue, right? There weren't fair housing implications there. Maybe it's her son took my son's bike, not necessarily a fair housing issue. Now, if it's that kid is only taking the bikes of kids from immigrant families, right? That could be an issue based on national origin. But if it's just, a kid stealing another kid's bike, it's not necessarily for housing issue, okay? His dog pooped on my front lawn. Ugh, not a great neighbor, right, to not clean it up, but not fair housing. Now, if it's, the neighbor is only choosing that one lawn and is making comments about, the fact that they're part of a protected class, then maybe it's a fair housing issue. But in general, probably not a fair housing issue. So, pop quiz. When is harassment a fair housing issue? You tell me. Oh gosh, you all get gold stars this morning. That's so good. Yes, when it is based on a protected class. Perfect. There we go. So I'm going to give you some examples of what this can look like. Sexual harassment. That is harassment based on the protected class of sex. So if it is happening in housing, that becomes a fair housing issue. Oftentimes what we'll see with sexual harassment is that it might be like, a maintenance worker that's harassing a single mom, right? Or harassing a single mom that doesn't speak English. That's oftentimes what we'll see is somebody being targeted who might already be more vulnerable. It could be, this is a case that came out of Florida, the second bullet point. It was this neighbor that would clean up after his dog when his dog went to the bathroom, but he would always leave the bags of poop on his lesbian neighbor's doorstep, on their little front patio. And he was very clear about his feelings about this lesbian couple living in this retirement community in Florida. That becomes a fair housing issue. Now, prior to my time working at the Fair Housing Council of Oregon, I actually worked at an organization called Cascade AIDS Project. I worked there for 14 years in their housing program. How many people have heard of Rentwell? I helped to create that. I helped to create that program. It's a really great program, and I taught it for many years, right? Now, when I was teaching that class, I had a gentleman come through my class that we were talking about fair housing rights. And after the class, he said, hey, I want to talk to you about what's happening with my neighbors. My neighbors are harassing me because I'm gay. They are yelling things at me. They're throwing trash on my balcony. Somebody peed on my front door. Somebody took a baseball bat to the windshield of my truck. And he said, I am reporting this to the landlord, and the landlord is not doing anything. So at that point, I said, okay, are you okay with it? Because I said, you should probably call the Fair Housing Council of Oregon. And he just said, I have so much going on. I don't feel like I can, because he's dealing with that trauma that's going on right there, right? So I said, and here's where, if you are an advocate or a case manager, here's where you can help. So I said, would you be okay if I called the Fair Housing Council for you? And I just do an initial, and I talk to them about what's happening. Would you be okay with that? And he said, yes, right? Get the release of information signed, did it. The person that answered the phone said, yes, that sounds like possible discrimination. Could you put me in contact with your client? So in that way, you can be an advocate for somebody that you are working with, because sometimes what I'll say is the folks that we work with at times may not have the easiest time always accessing systems. So you could be sort of that soft intro to say, hey, here's the things that I'm seeing, and that can be really, really helpful. What I'll say also is that on our hotline, we speak English and Spanish. We use a language bank for any sort of, language needs outside of English and Spanish as well. And we also work from a trauma-informed care model. Now, again, with all of that said, though, the need that is coming in is so great that we cannot meet all of the need that's coming in, frankly. So this is where it can be helpful if you contact us first, and you may have some also evidence that's built up, right, or documentation that's built up. In this case, what happened with him is that because he had had a shelter plus care voucher, right, functions a lot like a Section 8 voucher. So the Fair Housing Council helped to negotiate for him to get out of his lease without a lease break fee, also helped to negotiate with the housing authority so he could keep his voucher. And then after the whole thing was resolved, he filed a complaint against them and was able to get about $20,000. Now, does that make up for the fact that he had to deal with it? Right? It does not make up for the fact, but that does send a clear message to that landlord who is getting those reports and kept saying there's nothing I can do. It sends that clear message to the landlord that they have those responsibilities. Okay. Another example, harassing somebody with an assistance animal in a retirement community. This was a really interesting complaint that came up, and it was actually the housing provider that contacted us. And he said, I have this one tenant that has an animal for disability, And it's just this small little animal, and she, takes it around in a baby carrier all the time, or a baby cart, and all the neighbors keep harassing her about it. And the thing that was so interesting is the neighbors that lived in this retirement community, a lot of them were lawyers that were doing the harassing, so they should know the laws around this stuff. So proactively, that housing provider brought the Fair Housing Council in to do a training, proactively, which was a great idea. This was a case that I believe came out of Colorado. There was a man with a traumatic brain injury. He had been in a motorcycle accident. As a result, he had a traumatic brain injury, and it affected the way that he spoke and he walked and his motor skills. And the neighbor kids would harass him because of his disability. Now, this apartment complex had a pool in it, right? So neighbor kids are harassing him. He's reporting it to the landlord. Landlord's saying, there's nothing I can do. But who's responsible for the neighbor kids' behavior? It's the parents, right? So the landlord is not holding the parents accountable for their kids' behavior, because the landlord can absolutely give a notice because there's somebody in the household not following portions of that rental agreement, right? But the landlord's not doing anything, just says kids are going to be kids. Ultimately, this gentleman went down to take a swim in the pool. Somebody, like the kids, stole his shoes, his towel, his keys, his shirt, his cell phone, his wallet, and that was the point where his family helped him to get a lawyer. And this resulted in $160,000, right? And that's the landlord that has to pay for it. It's not the parents with those kids, okay? Now, this was a case that came out of the East Coast, and there was a woman that was experiencing really intense racial and sexual harassment in her HOA-governed community. I've read some of the quotes from this case, and they are horrendous. She was reporting it to the HOA, and the HOA wasn't doing anything to hold the other HOA members accountable that were perpetrating this. That settled for $550,000. Now, what I will say, these cases that settled for large amounts of money, they are the exception. It is very hard to prove harassment. And so maybe, Stephen, that's something that you can talk about, is how people could go about proving harassment, because it's a very challenging topic. Okay, so under that guidance that comes out from 2016 around harassment in housing, what a landlord should do. So the landlord, when they get a complaint, here's what the guidance says, is that if the landlord knows about the harassment or should have known about the harassment, they need to investigate it. Should have known means maybe it's a maintenance staff member that witnessed the harassment, but the maintenance staff member never reported it up. In that case, the landlord should have known, because it should have gotten reported up. Right? Should have known would be maybe it's the caseworker that says, hey, my client keeps getting harassed based on their disability from this other tenant right next door, or the person right below, or the person right above, right? So should have known might be that they get a report not from the tenant, but somebody surrounding the tenant, or somebody who is a staff member that witnessed, okay? So landlord learns of the harassment, then they have the responsibility to investigate that, and then also document. So one of the things that we find is sometimes when a landlord gets an initial complaint around harassment, there may not be enough documentation for them to move forward, right? So that initial complaint around harassment may be the thing that starts to establish the acts that are happening. I want to be clear about that. So how does that landlord find out what's going on? This is really helpful when somebody has some kind of documentation, right? Has those screenshots, has maybe those notes that have been left. What if it's one person's word against another? Well, the housing provider then might be interviewing each person, might interview witnesses. I talked to a resident services coordinator at one point that said, we have security cameras in the hallways that just record, visual, and it's for security, and it's in that public area, and we always record it, and somebody reported harassment to us, and even though we didn't have the audio, we could look at the body language of the one tenant versus the other and clearly see that there was something going on, right? An aggressive person, that happening, even though there was no audio. So sometimes those things can become very, very helpful. So you can answer this one for me. How does that landlord know if there's a fair housing issue? Beautiful. It's against a protected class. You all could teach this session for me. That's wonderful. Okay. So if the harassment is not is not against a protected class. What's the role of the housing provider? Could be ignore the disputes, but it might end up in the laundry room with one person throwing a big bottle of laundry detergent at the other, right? So maybe not ignoring it is the best idea. Mediation services, right? There are mediation services throughout the state that can help. These mediation services are often really aimed at helping to prevent what could ultimately become an eviction, right? They're a fantastic service. Also, having consequences for one party or both parties, it may be a combination of strategies. Now, if the harassment is a fair housing issue, this is where the guidance comes into play. The landlord should be taking prompt corrective action, like giving a warning or giving a notice. So let's say in the rental agreement, there's something that says you have to use the window treatments that were provided to you at the time of move-in, and then a tenant swaps it out and instead puts up curtains that have swastikas on it, right? So that landlord can then give the notice that says, in your rental contract, it says you have to use the window treatments at time of move-in, right? Those. So reminding, giving a notice based on that. It's important for landlords to be documenting every step of the way, what it is that they're doing, showing that they're doing due diligence, because then if an organization like ours or like BOLI or like legal aid calls, we want to know if that landlord's actually been doing what they're supposed to around that investigation. So landlords should be documenting. And also they should be following up with the victim to make sure whatever resolution that they came up with actually worked. And if they fail to act, that can be a violation of the Fair Housing Act. So this is actual language that comes from the guidance. So corrective action may include verbal and written warnings, enforcing lease provisions to move, evict, or otherwise sanction tenants who harass or permit guests to harass. Housing providers should follow up to make sure the corrective action was effective. And also this last bullet point, liability arises for the housing provider when the person or entity knew or should have known that a resident was harassing another resident and yet did not take prompt action to correct and end it. So let me be clear, this guidance is very specific if it is two residents or tenants in the same housing community, right? That's where this guidance comes into play. Let's say that I live in an apartment complex and there's somebody who owns a home next to me. We don't have the same landlord. So the landlord, my landlord, doesn't have that same responsibility. Make sense? Okay. All right, so ways to prevent harassment. It is advisable. A lot of rental agreements actually have resident on resident harassment policies, and they are usually in the rental agreement. It's also suggestible for landlords to use tools that they have around communication, like it may be newsletters, it might be e-blasts, it might be, some landlords have bulletin boards, some landlords will post things, in mail rooms or, in elevators. So it's really important that landlords are reiterating basically guidelines for community safety within their own apartment complex. So if you would like more information from us, from our organization, there's a few different ways you can get more information. So fhco.org, we have a ton of resources and information. You can also email us, information@fhco.org. Now, our education team also has a housing provider education hotline. So if a landlord is wanting more education or information about fair housing, they can contact us. Okay? And then we also, most importantly, have this renters' rights hotline. So people can contact that in 3 different ways. They can go online, fhco.org. There's this big, obnoxious pink button at the top that says, report housing discrimination. You really can't miss it. So that's one way that you can contact hotline, and you can, fill out the form that pops up for that 24/7. You could email enforcement@fhco.org also. And then we have live phone hours Tuesdays and Thursdays from 9 to noon. Where's Mario? I saw you walk in. Mario is our hotline manager. Everybody say hi, and also let him know how much you appreciate what he does. It's a hard job and it's a really important job. So if you contact Tuesdays or Thursdays, you will likely talk to Mario. If the phone line just keeps ringing, he's likely on the line with someone else. Call back during that window. Okay? All right. With that, I'm actually going to pass over to my colleague, Stephen.
Thanks, Shyle. Hi, everyone. My name's Stephen Crawford. I use he, him pronouns. I am the legal director at Fair Housing Council. The second half of this presentation was supposed to be about dispute resolution. Check, check. Yeah, it's a little better. Second part of this presentation was supposed to be about dispute resolution. That's what I'm going to try and talk about. Just so you're grading me on the appropriate scale, I want to I think Shyle may have already mentioned this before I walked in, but I was not originally slated to do this presentation, so I have nothing prepared. So, what does dispute resolution look like in a harassment case like this? Well, before I get into that, I will actually talk a little bit about evidence. Shyle mentioned it, and I want to talk about how difficult these cases are to prove. There are cases, and they're actually some of the more insidious cases where there's a record. One of the more insidious forms of harassment we see is someone has an emotional support animal or maybe a disabled child, and one or the other causes noise. Maybe not enough noise, but just enough to irritate the wrong person, and that person makes daily complaints to their landlord about that emotional support animal or someone's autistic kid for the rest of the time that they live there. That could also be harassment. The reason it's so insidious is because the person is making complaints about that person to the landlord. They're already on the defensive and being painted as the problem in this situation. So we see that a lot. What people who are experiencing this kind of discrimination should do, what I always tell people to do when I'm talking about them, buy a notebook just for the purposes of recording incidents of this harassment. Keep contemporaneous notes. As soon as something happens, if you're able, take out the notebook, write it down. Notes that are taken at the same time that an incident happens, they are evidence. The more contemporaneous they are with a situation, the better evidence they are. Obviously, if the harassment is occurring in a way that you can take pictures, for instance, Shyle used the dog poop on the doorstep example. Take pictures of dog poop on the doorstep. A lot of times we talk to people who experience something like this, their landlord or their neighbor did something that would actually be demonstrable through a photograph, whether it was graffiti or leaving behind waste or something like that. And we talk to them, and they're like, and first question out of our mouth is, did you take a picture of this? And you'd be amazed how often, even though this day and age everyone has a camera in their pocket at all times, people are like, no, I didn't take a picture of it. It's like, well, now we're in the he said, she said territory. And that's not a comfortable place to be in if you are the complainant in a fair housing issue. As far as video recording, you do have to be careful in Oregon. We are a two-party consent state. If you are going to record something over the phone, you do need consent from everyone on that phone call to record a phone call. If you are recording something in a private space could be a unit, like a dwelling unit. It could be like the back area, like the private office of the leasing office, back behind the counter where the residents don't usually go. If you're in a private space, that requires two-party consent. If you are in a public space, and that doesn't necessarily mean publicly owned, but open to the public, a parking lot, a leasing office that's open 9 to 5, then you just need one-party consent, and all the other parties need to be notified. They don't need to consent to being recorded, but they do have to know they're being recorded. Recording is great evidence, but since Oregon does have laws around it, you have to be careful in how it's done. So that's about getting evidence. The most common thing I would advise people is start a log. Get the notebook, start a log, record everything that happens. Also, if something is happening, make sure your landlord knows about it. A lot of times I'll talk to people who are experiencing this kind of harassment, and I'll say, did you tell your landlord about it? And they'll be like, well, the first time, yes. Like, what about the second time? What about the third time? No, because they never did anything about it the first time. It's like, well, if they know that there's a third, second, and fourth time, or a second, third, and fourth time, they might be more likely to do something about it, and at least we can show that they knew that there was a pattern of harassment developing. So if it's one time, there might not be a pattern of harassment. If it's multiple times, it might be a pattern of harassment, but if you didn't report it, your landlord didn't know about it. So reporting things obviously can also create a record, because we will always request documents from the landlord in a situation like this, and if they have a big tenant file that shows that they've received 15 complaints from this tenant about a particular neighbor, calling them racial or ethnic slurs, then there's not really a good argument that the landlord didn't or couldn't have known about it. So that's just about evidence. I'm going to start talking a little bit more now about dispute resolution. And I'll just start from what dispute resolution looks like from if you contact FHCO's hotline and engage one of our investigators, what's it going to look like from that point forward, and what other resources might be pulled into the resolution of a case in order to get it resolved. Our investigators are not neutral investigators. Unlike the investigators at Housing and Urban Development or BOLI, they are there as advocates as well as investigators. So if they believe that discrimination has occurred based on the evidence available to them, they will oftentimes, the next step will be for them to reach out to the landlord or housing provider and say, we think discrimination's happened here. In this case, it might be, there seems to be this pattern of harassment that seems to be pretty well documented. The record shows that you've been notified about it multiple times, and we've got questions and we've got demands. Our questions are what investigation and what investigatory actions have been taken, if any, and our demands are that if you haven't investigated this yet, do investigate it. Sometimes it ends there. Sometimes the landlord gets that letter, investigates the issue. Sometimes that investigation comes up with nothing. Really common issue that we have is, and this isn't necessarily harassment, but we'll have someone complaining about a neighbor who smokes and it's affecting their respiratory disability. Smoking can actually be a huge pain in the butt for landlords to prove is happening, because maybe the unit was built in 1965. It was smoked in for the first 40 years that it was there. It smells like perma-cigarettes. So they can't actually tell if someone has smoked there in the last month or so, or if the current tenant has smoked there previously, unless they open the door with a cigarette and hanging out of their mouth. So that I bring up that example to simply show that even a diligent investigation by the landlord sometimes will not come up with the findings that people expect. And if we get a case like that and we see like, it looks like the landlord did everything they could to see what was actually going on, we might not do anything further with that case. But if if we do feel strongly that there's something going on, the landlord has not done their due diligence, we'll make suggestions about how the landlord could do their due diligence. If the tenant has suffered anything financially, we may also include financial demands if we're pretty sure that the landlord hasn't done due diligence. Now, if none of that works out, those are our investigators reaching out as advocates to try to resolve the issue without any further steps. If none of that works, our next step will usually be to refer it to HUD or BOLI. We don't refer cases to the Department of Housing and Urban Development as much as we used to. Biggest reason being that in the last 7 months, they've pretty much ceased to be a reliable enforcement partner. BOLI is a much smaller agency. It's Oregon Bureau of Labor and Industries enforces our fair housing laws as well as our employment discrimination laws. It's a much smaller team they have over there, but they are active and they are dedicated to the cause. So we usually try to partner with them. Dedicated to the cause and upholding the law. They are neutral, and they are neutral themselves over there. So I don't want to give the impression that they're not neutral, but they are dedicated to the upholding and enforcement of fair housing laws. So at either of those agencies, the first step in resolution is going to be an offer of conciliation. The parties will be invited to conciliate. What conciliation is it's like mediation. There is a mediator that goes between the two parties. The two parties don't actually talk face to face, but the mediator goes back and forth. Here's their demands. Here's their demands. They might make slight suggestions to try to nudge parties closer to a settlement. And then what makes it conciliation as opposed to mediation is because there is a public entity involved, the government, they are also conciliating the government's interests, which will include something that is for the public interest. So for instance, when Housing and Urban Development was still handling cases and not just shipping them off to Washington to disappear, they would require that all of their conciliations included fair housing training for the housing provider. So even though the conciliation doesn't include a finding of fault, when those are issued, neither party's admitting fault; they're just settling the case. But HUD wouldn't do it unless the housing provider agreed to fair housing trainings, or in certain cases could show that they've done fair housing trainings within like 6 months in the past, which I think is a little bit backwards, because if they did one that recently and then violated, then it clearly didn't stick. They should do another one, but that's the way HUD does it. So Bully has a similar process. There's not really anything different there. The HUD investigator acts as a conciliator. Unlike our investigators at FHCO, HUD and Bully are genuinely neutral, so they don't take sides. Their effort is to uphold the law and resolve the conflict. There are also third-party or private dispute resolution resources out there. I believe this was supposed to be with Resolutions Northwest initially. They're probably the biggest free resource in Portland for dispute resolutions. They do all kinds of housing. It's not just between housing providers and tenants, but for landlords that might be trying to resolve a housing harassment situation. They also provide dispute resolution between neighbors. So if it's not clear that the issue can be resolved through landlord action, but it's clear that there is a dispute between two tenants, then organization like Resolutions Northwest might be the right answer. Further south in the Willamette Valley, you have neighbor-to-neighbor resolutions. They're the same kind of outfit. I'm actually not sure beyond that geographically what resources might be available through the rest of the state, but Portland and the Willamette Valley, you have Resolutions Northwest and neighbor-to-neighbor. So they provide mediators in order to reach those resolutions. What haven't I talked about as far as resolutions? Obviously, the worst way to resolve a case, and I'm saying this as an attorney, is to argue about it in court, but that is technically a method of resolution. Why is it the worst? It is time-consuming, it is resource-intensive, and no one comes out of it happier than they went in. I've never seen someone happier, even the people who win their lawsuit, never leave their lawsuit happier than when they went into their lawsuit. They might come out with more money, or they might come out with some resolution to their problem, but they very seldom feel like they've been truly made whole. They very seldom feel like they can continue to live in their community safely. So what would that look like? That is literally just hiring a lawyer and filing a lawsuit. On our end, we do help with that kind of thing. FHCO is not a law firm. However, what we do for cases that look like they need to be a lawsuit is we will help people find attorneys, whether that is a referral to our partners over at Legal Aid and Oregon Law Center, or whether that is helping someone find a private attorney from the pool of private attorneys that agree to take cases from us. Agree to entertain cases from us, I should say. So that is our worst case scenario. That is where we turn when we are out of options for resolving a conflict, is we start looking at litigation. I think that pretty much covers the various forms of dispute resolution I can think of. I'm happy to answer questions when we get to that point, and I'll let Shyle have the microphone so we don't have to do that.
Trying to see if I can get this mic. I don't seem to be able to get this mic to work. That's okay though. Are there any questions that folks have? Please. Okay, so we're going to repeat all the questions that get asked since this is getting recorded. So April said, we had mentioned recordings that got made like in the hallway, but, wants a little more discussion around recordings possibly in private spaces, in more common areas. And Stephen, do you want to take that question?
Yeah, so I'm imagining like a common area is like a controlled access area of the building where tenants can get to, but it's not open to the public. I would say that if I were an attorney advising a housing provider in that situation, what I would advise, or a housing, like if you're a housing provider wanting to put up security cameras, closed circuit television, what I would include in a rental agreement would be something that that says, by entering this rental agreement, I am consenting to surveillance that occurs in the common areas of the facility. That would probably be safer than just posting a sign saying you're being recorded, since that is technically a common area that's not access to the open to the public is technically a private space. I think you would technically need consent, not just notification to record there. So, but I believe putting something in the rental agreement that they sign would be sufficient to get someone's consent to being recorded in those public spaces. As far as more public spaces, you know, the parking lot, it's technically only for tenants, but anyone can get into a parking lot. The leasing office, if it's 9 to 5, people can record in those spaces as long as someone is notified. It is considered notification if you're recording openly, so you're just holding your phone up and very clearly recording people. That's considered notification. I think I'm going off on a tangent now. I think I answered your question. Cool.
Yes, please. Okay, so the question is, the resident is already living there. Could they add an addendum to have the resident sign that specifically around the recording?
Yes, you could ask a tenant to or a resident to sign an addendum. The housing providers could do that. I think the problem that would be conceivable is if a resident refuses to do that. You know, there's not a remedy if a resident refuses to sign an addendum to a lease. In most cases, there's some exceptions in landlord-tenant law, but that's not what we're here for, so I won't get into it. The drawback of that might just be simply that a housing provider might not be able to use recording of that particular resident as evidence if they really refuse to sign the addendum. That's my best guess. You know, this isn't necessarily something that's been through court to figure out like what happens on the.
So
Sorry, say that
the
again.
follow-up question is, so you must have permission?
Yeah, you really do have to have that consent or permission to record people in private spaces.
Other questions, please.
Yeah, I can recap the question. Yeah, so to recap the question, and it was a multiple part question, so please remind me if I leave any part of it out. Was what to do in relation to ICE when one neighbor is harassing another neighbor by threatening to call ICE, and I think also bringing that to the landlord to tell the landlord that they were going to call ICE as well? Okay. Interestingly enough, there was, and this is a landlord-tenant situation, yeah, not like a housing authority or a homeowners association or something like that. Well, in the landlord-tenant situation, there was a new Senate bill passed this year that prevents landlords from disclosing a tenant's immigration status for the purpose of harassing or retaliating against that tenant. Senate Bill 599. So this wouldn't I'm just starting here because it wouldn't necessarily apply to the neighbor, but it would apply to the landlord who learned about this through the neighbor. The landlord wouldn't be able to then take that information and then contact ICE and disclose the tenant's immigration status. What it means for the neighbor that's disclosing it, Senate Bill 599 might not be much help, but I do want to emphasize that while we're talking about harassment, and we've talked a fair amount about how the housing provider can be held liable for harassment and discrimination, neighbors can be held liable too. And so if someone is using someone's immigration status to harass, threaten, coerce, or intimidate them by threatening to call ICE, well, there's not a federally protected immigration status, but we do have national origin as a protected class. And since most people with a non-citizen immigration status, well, frankly, all people with a non-citizen immigration status will be able to identify as being another nationality other than American. And if you're having ICE called on you, let's be realistic, we can probably narrow down the demographics from there. Then that neighbor is very possibly being held, it's very possible to hold that neighbor liable for the harassment, intimidation, and coercion that's happening to that person on the basis of their protected class. Now, you also asked your role as a case, you said you were a caseworker or a...
I'm supposed to be doing program development, but I do a lot of casework too.
Okay, but the role of a caseworker in that situation, I think is just to, as far as I can think, first of all, you can always report this kind of discrimination to Fair Housing Council or to Bureau of Labor and Industries. For either organization, you don't need to be the person experiencing the housing discrimination in order to report it. You can be a person witnessing it or aware of it because you're a caseworker, or we also get complaints from employees of housing providers pretty consistently too, that are worried that their employer's not following the law. So any of those can be a source of a complaint. The other thing that I would encourage for caseworkers is make sure you understand your non-resident client's rights and to communicate those rights. For instance, let's say it's too late and ICE has been called. Make sure your clients understand that an administrative warrant issued by ICE is not sufficient for entering a dwelling. It has to be a signed judicial warrant if they want to come into a living space. So those kinds of things can help people be a little more safe in understanding that they don't have to come outside of their home if ICE is demanding for them to come outside of their home. They can stay inside where it's safe, and ICE is not allowed to go in. So that kind of education, knowing your client's rights and advising them on those rights, I think is the biggest role that a caseworker can play. And obviously reporting discrimination when you witness it also gives your client also gives non-citizen clients an extra level of protection by not making them be the first person to have to reach out and exposing them to even more risk. Not that they necessarily would be, but they're living in constant fear, so they don't know when they reach out to a resource, is that going to expose them to even more risk than they were previously exposed to? So that kind of thing can be helpful. Did I touch all parts of your question?
Yeah, thank you. I guess like one follow-up would be the line between sharing like know your rights information and giving legal advice.
That's a great question. Yeah. Your question was to know the line between giving legal advice and giving someone know your rights information. And this is actually something, and Shyle might be able to add, because this is something our team has to do really constantly, because we're not, well, I am, but most of our team's not lawyers. So we also have to follow that divide, and I'll let Shyle explain how she does it.
Yeah, so how we think about that, because we do this disclaimer a lot when we're doing trainings, because, you know, our education team, not attorneys. Glenda's close, but, you know, not attorneys. So basically, we can give information about what the laws are and what the laws say. But then if somebody says, here is my specific situation, how do these laws apply to my specific situation? And then we start saying, well, here's how the laws apply, and here's what you shouldn't do. That could get construed as legal advice. So that's different than like you're client that you're working with is saying, here, my neighbor is threatening me. You can say, here's information. Here's what the law states. You know, here's what people are able to do with the law, right? But if you start saying, well, you should do X, Y, and Z, and here, help me, like, I'm going to help you plan out exactly what you're going to do around that, that could start to get construed as possible legal advice.
Yeah, I agree with all of that. When there's an interesting phenomenon when you're in law school where everyone immediately starts treating you like you're an attorney as soon as you have your first class. And law professors actually tell us how to deal with that because law students can't give legal advice either. The most frequent advice that we give out is, please talk to an attorney. So that's just a segue of saying, sometimes if you think someone needs more specific advice and you're not comfortable giving it to them, try to connect them to Legal Aid or Oregon Law Center, especially if they are non-English speaking. They accommodate for all of that, and they are definitely tuned into and interested in these immigration issues. So I definitely am a big fan of Legal Aid and Oregon Law Center and think that they're a great resource they're a resource that is in high demand, but they're a great resource, and I think their attorneys know housing law better than anyone else in the state. So that would also be a good thing to do if you're uncomfortable answering legal questions.
All right, any other questions? Please. Great question. So it's how does the tenant navigate it when it's the landlord that is a private owner that is the one doing the harassing?
Well, it's no longer about asking the landlord to investigate the issue because we would no longer trust the results of such an investigation, obviously. From FHCO's perspective, and this is actually the more common scenario than a neighbor being the issue in our experience, it's usually the housing provider or one of their employees that is the problem. And when we get cases like that, what we do is we open up an investigation and start gathering evidence. And if we can gather evidence that indicates that the housing provider was harassing a tenant, then, and if it was fair housing, so it was also, I will also add that if it is a landlord harassing a tenant, it doesn't necessarily need to be fair housing to be against the law. It's illegal for landlords to abuse certain rights or to violate a tenant's quiet right of enjoyment. So they might have liability just under landlord-tenant law, but if it's connected to a protected class, they also have liability under fair housing law. So, that could just end up in a direct lawsuit or administrative complaint against the landlord for the direct harassment. It doesn't necessarily have to be, landlord, did you investigate your own conduct? It's more so, landlord, you did this. Our first letter is going to be less about the results of your investigation and more like, these are our demands to rectify this situation. And if the landlord's not cooperating, we'll go through the enforcement process as we talked about earlier, helping people with the HUD or BOLI conciliation process. And if none of that is going to work out, ultimately referring people to attorneys for litigation. So that goes from the landlord being held responsible for not investigating a situation to just being the bad actor in that situation from the get-go. Does that address your question?
Yes.
Yes.
Definitely. All right, any other questions? Please. All right, so the question is, let's say that there's a new tenant that moves in that meets some of the other tenants, and another tenant sort of targets that one tenant that just moved in and starts emailing the landlord about, I think this tenant is doing X, Y, and Z. At what point does that cross into harassment?
Yeah, this is kind of that insidious situation I was talking about earlier. I would say that this is why documenting as a housing provider is important. Not just what is reported to you, but what is done about it. So let's say a tenant reaches out and says, you know, my neighbor's dog barks 24 hours a day, never stops. The housing provider happens to know because of the particular household that the dog in question is an emotional support animal or a service animal, which then lands this into fair housing territory. The housing provider does an initial investigation, goes, checks it out, they listen by the tenant's door for a little while, the dog's not barking, they knock on the other neighbor's door, they say, hey, have you had any problems with this neighbor's dog barking? That neighbor says no. They've done their investigation to the extent where they at least think that the neighbor sending the emails is not being honest. They should then have a conversation with that neighbor about making accurate and honest complaints and why it's a problem when they don't, and encourage them not to do that anymore. And then if they continue after that and they continue to be frivolous after a remedial action has been taken, I would say you're very safely in the harassment category. Yeah, I mean, it could happen before that, but I would say to feel very, very safe that if a remedial action has been taken and it continues after the initial remedial action, then you're very safely in harassment. Then you're out of, miscommunication, misunderstanding territory, and then you're into harassment territory. Is that?
All right, question in the back. Absolutely. Great question. So it's what kind of resources are there out there to help people learn how to advocate for themselves? Okay. That's the essence of it, correct? I will say it's not 2,000 calls that we get, it's 2,000 contacts because we also use virtual contact methods. So to be very clear, because some people will think we don't have a hotline outside of Tuesday and Thursday, and we absolutely still have a virtual hotline that's open all the time. Okay, first step for helping people learn how to advocate for themselves, right? Because this is a real challenging thing to learn how to do. First step, educate people about what their rights are. We have a lot of great information on our website, fhco.org. If you go to the education tab, there's basically, you hit resources and there is so much information on there. It is fantastic. So number one, first educate people about their fair housing rights and their fair housing rights that they need in that moment, right? What I have found teaching for a lot of years is that we can teach people about a lot of information, but unless they actually need it right then in that moment, it will oftentimes not stick, right? So educating people about their specific needs. We also have online recorded trainings so people can learn more about their rights in that way. And then I would say around learning how to advocate for oneself, that is a much more challenging thing, right? How do I advocate for myself? How do I speak up for myself? That is more challenging. And one route that I have found is very helpful for people learning how to advocate for themselves is through the Rent Well program. That whole program is based around how do you advocate with a landlord if you have housing barriers. But what I heard time and time again was that even people who they would use the same advocacy framework that gets taught in Rent Well to resolve other problems in their life as well. So I would highly recommend that as a resource if people need to learn not only about their rights, but also about how to advocate, because there are some very clear conversations that happen. How do you advocate for yourself in writing, and how do you advocate for yourself through conversation? And you would find both of those things within that program. Please. It's a great question. So there are certain types of words that can get used, slurs that can be used towards, for example, women, that are very commonplace within the vernacular, right? And at what point do those words go from being just commonplace in vernacular versus actually being part of harassment? Context, I'll say that. Context really matters. Who's saying it and what's the context? Because there are things that my female friends, female identified friends, can say to me that I'm not going to have a reaction to, but somebody outside of that, like, I even have a reaction when somebody says to me, "you guys," meaning everybody, and I'm like, oh, I'm not a guy, right? So then at what point does that become harassment? Have I made it clear that that's not an acceptable behavior, right? I actually had to learn the legal definition of harassment and when it can get reported, because I had a neighbor's boyfriend who kept sexually harassing me. And the first step of that was I actually had to let him know this behavior is unacceptable. That was actually the first step, because if I didn't say this behavior is unacceptable, that didn't necessarily establish the harassment. So that is a really key piece. This behavior is not acceptable to me. And then I'm going to pass it over to Stephen to see, because I'm sure there's something beyond this.
Yeah, I would say there are certainly ways where even if the person being harassed doesn't disclose that it is unwelcome behavior, I would say if someone scrolls the C word, with their keys across the side of someone's car, that it's unwelcome behavior. So that can be inferred in some cases, I think, without it being a problem. But as far as when I don't have a lot to add beyond that, except for it really just depends on the context and people, having enough common sense that they understand that something that is repeated and ongoing and unwelcome is harassment, and something that is, if someone lets the B word fly in a fight, that, people get in fights and it doesn't necessarily make it harassment. Someone lets the B word fly, it might not be harassment, but then they continue to shout at that person's door every time they walk by the B word. Now we're starting to enter into the harassment territory. So it is.
Yeah. So the follow-up question is it hate speech? And here's what I'm going to say. This is why this question is so hard to answer, because it really is so dependent on context. And there's not cut and dry answer for context as far as when the context would indicate this, yes, is harassment versus no, this is not harassment. So it is so dependent upon context. And this is where, like, we start to tell people, like, if it is actually happening, legal advice, right? That's the point where you start to get legal advice. So we can't really go much beyond that because it's so context dependent. Yeah, please come up afterwards. All right, folks, it is 11:45. Thank you so much. Special thank you to Stephen for stepping in at the last minute. Really appreciate him, and please feel free to come up and ask us questions afterwards. We're here at the conference the whole time, too, so if you just happen to see us, we're happy to talk.